All right, here we are again. In this unit, we're going to focus on one specific type of assent communication, the offer. All right, in this unit, we're going to focus on the offer. First, we're going to look at the definition of offer. We're going to talk about other names for offers that you might see. We're going to talk about terminations of offers. When does the offer die? We're going to look at offers seeking return promise, right? An offer seeking return promise, and hopefully you understand that that means we're talking about an offer seeking to form a bilateral contract. We're also going to look at offers seeking return performance, and hopefully you also recognize that as an offer seeking to form a unilateral contract. Finally, we'll talk about ambiguous or different offers. Those are offers where the offeror is not clear or is indifferent about whether she wants acceptance by return promise or return performance. More on that later. All right, let's talk about the definition of an offer, and let's talk about other names for offers. So the definition of an offer is a manifestation of a willingness to be bound immediately upon the offeree's acceptance. So we've been using these terms, but we haven't introduced them, right? The person who makes an offer is the offeror. The person who receives the offer is the offeree. As soon as the offeree accepts an offer, you are bound. So an offer is just a manifestation of a willingness to be bound as soon as the offeree accepts the offer. You don't have to actually use the word offer, right? The examples I've been saying is that I will buy your house, I will buy your car for $100. Once again, you don't have to use any kind of specific language. The question that you have to ask is, would a reasonable person have understood that you are manifesting a willingness to be bound as soon as the offer is accepted? This is the objective approach to contract. Now, there are a couple other names for offers. Sometimes they're called bids, sometimes they're called orders, right? When you make an order, when you order something online or you order something from a catalog, when I was a kid, we filled out an order form. That is an offer. You are making an offer to buy those goods. And then when the seller receives that offer, that order, they can decide whether they will accept your order or not. One important principle that you have to understand is that the offeror is the master of the offer. The offeror controls the offer. So, for example, if I say, I make this offer to you and you can only accept by standing on your head and spinning, then the only way you can accept my offer is by standing on your head and spinning. Hopefully no one does something that silly, but that is the power of the offeror, to be the master of the offer. And to that extent, kind of previewing what we're going to be talking about later in this subunit, is that if I'm an offeror, I can tell you if I want you to accept by performance, right, and thereby we enter into a unilateral contract, or if I want you to accept by promise, right? You return promise to me, and thereby we will enter into a bilateral contract. I can also, as the master of the offer, tell you what medium that I want you to accept by. So if I say you can only accept my offer by email, then that's the only way you can accept my offer, right? And manner of acceptance. I can dictate through my offer what manner you should accept my offer. And this is promise or performance. All right, let's talk about termination of offers. What type of events result in the termination of an offer? So let's just start out with an offer. My favorite offer, I will buy your car for $1,000. Well, how will that offer terminate? Will that offer be open forever? It will terminate when it has expired by its terms. Now, my offer didn't have any expiration terms, but I might put in some expiration terms. So I might say, I will buy your car for $1,000. You have to accept this offer by Monday, right? Then Monday passes, the offer will expire after Monday passes. So an offer will terminate if it expires by its own terms. Now, if I have an offer that does not have a duration, I will buy your car for $1,000. That offer will expire when it lapses, right? That offer will terminate when it lapses. And that just means after a passage of a reasonable time, right? A reasonable time is factual. I can't tell you what a reasonable time is in every situation. You have to look at the facts of the case to determine whether the offeree accepted within a reasonable time. But the offer will lapse after a reasonable time has passed. The offeror can revoke the offer at any time. So if the offeror revokes the offer is now terminated. If the offeree rejects the offer, we discussed this a little bit earlier, if the offeree rejects the offer is now terminated and the offeree can no longer accept that offer. A counteroffer is the same thing as a rejection. A counteroffer operates as a rejection and a new offer. If the offeree makes a counteroffer, the original offer is now terminated. Death or incapacity of the offeror. If someone makes an offer and then they die, the offer dies with the offeror. Now, that doesn't mean that a contract will die with one of the parties. If party A and party B enter into a contract and party A dies, that contract does not die, right? If party A owes money or owes performance under that contract, party B can sue party A's estate to recover after party A has died. So think about this. If I borrow money from a bank and I promise to repay and then I die, my debt does not die with me. That contract does not die with me. My estate still has to make up that debt. But if I make an offer and before you accept that offer, I die, then the offer dies with me. The offer also dies with the offeree. So if I make an offer to you and you die, then the offer dies with you. Let's continue our discussion of offers and let's talk about a special situation, the promise to keep an offer open. So let's say the offeror says this: I promise to keep this offer open until October 15th. Is offeror allowed to revoke that offer before October 15th? And the answer is yes. Okay? Offeror can revoke the offer any time before the offeree accepts it. Now, we'll discuss this issue again, and we'll talk about when a promise to keep an offer open will be binding, but right now a promise to keep an offer open is not binding. The offeror may revoke that offer at any time before offeree accepts, even if the offeror promises to keep the offer open. Okay, once again, more on this in Unit 3 when we discuss consideration. All right, let's talk about the offer seeking return promise, right? Hopefully you recognize this as an offer seeking to form a bilateral contract. It is a contract where both parties make a promise. We've given examples of this before. I promise to sell my house to you. You promise to buy my house. It's a bilateral contract. Remember, the offeror is the master of the offer. So the offeror can dictate whether the offeree must accept by promise or performance. Okay? If the offeror is seeking return promise and not return performance, then the offeree can only accept by promise. The offeree cannot accept by return performance. But naturally, usually when parties enter into contracts, they don't specifically say, the offeror doesn't specifically say, and you can only accept by return promise. It is implicit in the language of the offer and the circumstances. Once again, we take an objective approach to contract formation. Would a reasonable party understand that you were seeking return promise? Or would a reasonable party understand that you were seeking return performance? We will discuss acceptance of these types of offers. We will discuss acceptance of offers seeking return promise when we move into the subunit on acceptance. All right, let's talk now about the offers seeking return performance. Hopefully you recognize this as an offer seeking to form a unilateral contract. Once again, a unilateral contract is a contract where one party makes a promise and the other party does not. The other party can accept the promise by what? Full performance. All right, once again, we'll repeat this principle. It's a very important principle. The offeror is the master of the offer. And so if the offeror is only seeking return performance, then the offeree can only accept by full performance, not by promise. Okay? Oh, we just said that. All right, remember, full performance, not partial performance. So if an offeror makes an offer seeking performance, then beginning performance on the part of the offeree is not acceptance, partial performance is not acceptance, only full performance operates as an acceptance of the offer. This is the objective approach to contract. Again, we run into this issue. The question becomes whether a reasonable person understood the offer to be seeking return performance. We're going to discuss this in more detail when we talk about acceptance of offers seeking return performance. All right. There are several common circumstances where the offeree should reasonably understand that the offeror is seeking a return performance and not a return promise. All right, let's look at those circumstances. First, we have the reward offer. I will pay $1,000 to you if you find my cat Fluffy. I am not seeking a return promise from you. I do not want you to say, I promise to find Fluffy. I want you to find Fluffy. All right, now, also consider this. If you promise to find Fluffy, and you are now bound to that promise, if you don't find Fluffy, you are in breach of the contract. So I don't want you to promise to find Fluffy. I just want you to do it. If you do it, I will pay you. Otherwise, you are not obligated to do so. The contest is very similar to the reward offer. The contest offer, for example, if you hit a hole-in-one on the 5th hole, we will give you a brand new car. Once again, I don't want you to come to the 5th hole and say, I promise to hit a hole-in-one. And of course, you would be foolish if you made such a promise. The bonus incentive contract. Remember the employer who said to his sales staff that he would pay a bonus to the salesperson with the highest sales volume, right? That is the bonus incentive contract. That employer did not want any of the employees to say, I promise to have the highest sales volume. The guarantee contract. This is the guarantee contract. Now, the guarantee contract is something that may be a little foreign to you. A guarantee is when you promise to answer for the debts of another. Here's an example. I go to bank and I say to bank, if you lend money to my friend, I will guarantee it, which means if my friend cannot pay back the loan, I will be responsible for it. That is a guarantee. you can see how it is articulated as a unilateral contract, as an offer seeking performance. I say to the bank, if you lend money to my friend, you're not obligated to, but if you do so, I will act as guarantor. Now, let's just take this time to go on a little tangent and talk about the difference between a guarantee and a cosign. When you cosign a loan with your friend, both you and your friend are the borrower. You're both equally responsible under that contract. We'll say you're jointly and severably liable. All right, the guarantee is different. When you act as a guarantor, you are not liable. You are not liable for the obligation until the primary obligor, in this case the borrower, defaults on the loan. And finally, we have the insurance contract. Most insurance contracts are unilateral contracts. The insurance company says to you, if you pay your premium, I will compensate you. I will indemnify you upon the happening of a specific event, say a fire. If you do not pay your premiums, you are not in breach of the contract. You are not in breach of the insurance policy. You just don't have coverage. Let's talk about ambiguous or indifferent offers. Now, what I mean by an ambiguous offer is where the offer is ambiguous about whether the offeror is seeking return promise or return performance. When I talk about an indifferent offer, the offeror is indifferent. The offeror doesn't care whether you accept by promise or performance. Okay, so here's a simple example of what I consider to be an ambiguous offer. If you mow my lawn tomorrow, I will pay you $100. So am I seeking a return promise from you, or am I seeking a return performance from you? I think it's ambiguous. Let's talk about an indifferent offer. So let's say I make the same offer. I say, if you mow my lawn tomorrow, I will pay you $100. And then I say, let me know if you will do it, or just show up and start in the morning, right? Just let me know if you will do it. That's saying you can accept by promise. Let me know. If you just show up, or just show up is saying that you can also accept by performance. So here I'm indifferent about whether you accept by promise or performance. Let's continue our discussion of ambiguous or indifferent offers. How can you accept one of these offers? Well, let's refresh our memories. An offer is ambiguous or indifferent if the offeror is ambiguous or indifferent about whether she is seeking return promise from the offeree or return performance from the offeree. So what if we do have an ambiguous or indifferent offer? How can the offeree accept that offer? Well, the offeree has three choices. The offeree can either accept by promise or by beginning performance, not full performance in this case. In this case, beginning of performance is acceptance. Or the offeree can accept by tender of performance. Now, I don't think we've introduced the idea of tender before, but tender is just saying, here, I'm ready to perform. So, for example, if my obligation under a contract is to make payment, right, giving you the money is actual performance, is actual payment. But saying, here's the money, I'm ready to pay you, that is tender of performance. Tender of performance just means offering to perform with the present ability to perform. So, an offeree to an ambiguous or indifferent offer can accept by either promise, beginning performance, or tender of performance. Now, here's the kicker. Under all of those circumstances, under all of those manners of acceptance, we have a bilateral contract. So, if the offeree accepts the ambiguous or indifferent offer by promise, naturally, both parties are bound. The offeree is also bound. We have a bilateral contract. But if the offeree accepts by beginning performance and not promise, the law says that that operates as a promise. So the offeree accepts by beginning performance. It's as good as making a promise. Both parties are bound, the offeror and the offeree. And similarly, if the offeree accepts by tender of performance, that operates as a promise, and both parties are bound, the offeror and the offeree. Now, how is this different from what we've seen before? So, when we talked about the unilateral contract, the contract where the offeror is seeking return performance, what did we say was acceptance? Full performance. When is the offeree bound? Never. If in a unilateral contract, the offeree begins performance, that does not operate as assent. That does not operate as an acceptance. So, for example, if you say to me, if you go to the roof and retrieve my baseball, I will pay you $20, and we look at that as a promise seeking return performance, a promise seeking to form a unilateral contract. When I start to go up, I have not accepted your promise. We are not yet in contract. And I can at that point say, you know what, I don't want to do this, and I am not in breach of contract. But if you make an ambiguous or indifferent offer to me, and I start performance, I am now bound. That operates as a return promise.